Well, good morning, everyone. Is my mic working? Sounds like it. Can we hear this? I think so. Okay. Thank you. Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Friday, May 10th, 2024. The time is 9:31 a.m. With us today are Commissioners Bobby Janeca and Katerina Gonzalez, as well as our General Counsel, Mary Smith, and I'm John Neerman. For those of you who are going to address the Commission today, we'll ask you to, we'll inform you of your time limits, and for those of you who would like to speak on a particular item and have not yet registered, we'll ask you to visit our registration table out front or email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we'll do our best to accommodate that request. I want to thank everyone for being present today. I want to thank the Workforce Commission again for hosting our meetings while we're temporarily displaced. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the application of the City of Wichita Falls for water use permit number 13404. I'd like to begin by acknowledging that we have a large number of individuals here in person and online, and that their presence will be noted for the record. The parties have been notified that the applicant and the protestants collectively will each have 10 minutes of oral argument, while the ED and OPIC will each have 5 minutes. The order of presentation for the parties will be the applicant, the ED, and then OPIC. The applicant may reserve time for rebuttal as the applicant bears the burden of proof on this matter. As a courtesy, the Commission allows members of the legislature or their staffers to address the Commission on items at its open meetings. And we do have someone here from Senator Springer's office to address the Commission. As a reminder to the commissioners, under the Texas Administrative Procedures Act, Texas Government Code Section 2001-141, their decision today must be made based on the evidence admitted in the administrative record and matters officially noticed for this meeting, including the arguments of parties and the ALJ's proposal for decision and proposed order, and the administrative record. We will begin this matter then with Jonathan Mathers from Senator Springer's office.
Well, Mr. Mathers is coming up just for my confirmation. 10 minutes for the applicant, 10 minutes for protestants, 5 for the executive director, and 5 for OPIC.
Correct.
Okay, got it. Good morning, sir.
Good morning. Thank you for having Senator Springer here today. And just want to say what a great job Catherine and the government relations team has done for us and your technical staff. We have a few pending issues with TCEQ in our district, and your staff has been tremendous. Thank you. I have a letter here from Senator Springer, and I understand that I need to read this to get into the record to avoid any ex parte communication. So forgive me for reading this out loud. I know when I go to seminars and conferences and people read their speech, I roll my eyes, and I beg your indulgence. Per Senator Springer, I am deeply grateful for your attention to this matter. The critical work you do to ensure the environmental quality of our great state is of utmost importance. It has been an honor to serve the people of Wichita Falls and surrounding areas over the past 12 years, first as a state representative and now as a state senator of Texas. Throughout this period, I have engaged in extensive dialogue and gathered significant information about the proposed Lake Ringgold through town halls and meetings with various public officials on both sides of this issue. The primary consideration in deciding whether to grant the City of Wichita Falls the permit to construct Lake Ringgold should be whether the city's need for water justifies the exportation of private property through eminent domain. The proposed reservoir, if approved, would displace hundreds of Texans, flood valuable agriculture and wildlife areas, diminish the Clay County tax base, and impose a staggering financial burden of over $500 million on the water ratepayers of Wichita Falls, Burke Burnett, Iowa Park, and other communities. The Honorable Christian Seo, Administrative Law Judge for the State Office of Administrative Hearing, in his comprehensive analysis of the project during the contested case hearing, stated that the city has failed to meet its burden of proof on several critical criteria. Most notably, the city could not establish a need to appropriate the requested amount of water. A memo dated January 29, 2019 from the Wichita Falls City Manager informed the City Council that the operational indirect portable reuse facility would minimize the impact of any future drought on residents' quality of life. He also noted that Lake Ringgold would supply more water than is needed to the city. The memo reveals that the city effectively utilizes alternatives like desalination, for which we shouldn't commend the city. Furthermore, the city manager is yet to discuss the full review of existing lakes controlled by Wichita Falls for dredging and raising dams to create more available acre feet, despite my raising these concerns for quite some time. The dredge dam operation would have water available decades before a reservoir could be built at a more economic number and without the taking of land and economic opportunities from neighboring communities. Therefore, the city should continue to explore and adopt more modern options than building new reservoirs. In light of these findings, I urge the Commission and the esteemed body responsible for safeguarding the interest of our community to carefully consider the significant ramifications of approving Lake Ringgold project. The evidence suggests that the proposed reservoir is unnecessary and could lead to substantial and unjustified economic and social costs to the community. Therefore, it does not meet the necessary burden to justify using eminent domain to confiscate the private property of Texas citizens. Respectfully submitted, Drew Springer, State Senator for SD 30.
Thank you, sir. Appreciate that. We certainly appreciate the senator's interest in this matter and his service to our state. Thank you.
And I have copies of the original letter that I'll leave with the clerk.
Thank you.
Now we'll have Nathan Vassar for the applicant.
Good morning, sir.
Good morning. Morning to Chairman, Commissioners, General Counsel, Executive Director, and staff. My name is Nathan Vassar. I represent the applicant, the City of Wichita Falls. I would like to reserve 5 minutes of my time for rebuttal today. With me today are the City Manager for Wichita Falls, Darren Leiker, as well as the Director of Public Works, Russell Schreiber. They're here because of this application, but they are also here because of the more than 150,000 residents who are served across the region by water supply from Wichita Falls, more than 70% of the entire Region B area. And they remember what was largely the driver for this application, the devastating drought of not even 10 years ago, when the city nearly ran out of water. The city didn't sit idle. The city pursued this application and they prosecuted it. They looked at alternative after alternative after alternative, and one solution was clear: Lake Ringgold, for a water supply future that would be secure for the entire region. Commissioners, this permit and this application, they are defensible. When you hold up the actual TCEQ regulations, when you hold up the water code and compare it to the application, there's one conclusion and it's clear: the city has met its burden. The Executive Director agrees with this conclusion, and even OPIC agrees with this conclusion. And beyond those two entities, this project has been supported by other entities as well. The Texas Legislature has twice considered and approved Lake Ringgold as a unique reservoir site. In addition, the Water Development Board, our sister agency, has included Lake Ringgold in its state water plan and the regional water plan since 2006. Commissioners, I want to talk about the issues where the ALJ contends that the city failed to meet its burden. But first, I want to talk about what that burden is. Burden, as we know, is a preponderance of the evidence standard. It's not more than that. The burden is on the city, not on executive director staff. And finally, the burden is a state burden. It's a TCEQ burden, not a Federal Army Corps of Engineers burden, and not a Water Development Board burden. I mention that because the PFD gets several of these issues wrong by looking at them through those lenses. First, the issue of consistency with state and regional water planning. The statute is very clear. It's looking for consistency with something else that's already in existence. Commissioners, I dare say if you were to ask ED staff how many times they decide to redo the work of the Water Development Board, the answer will be 0. They don't veer into the lane of the Water Development Board. Those plans are already developed. They're already thoroughly vetted. And so when the PFD plucks out the word need, it's asking for, is this water application consistent with something that's already been done? Separately from that process, the Water Development Board, there's a federal process that looks at needs called purpose and need under the Army Corps of Engineers 404 permitting process. That is not before you today. The application with consistency with state and regional water plans, that is here before us today. On the issue of habitat and mitigation plan, another area where there's a distinct difference between what's in the state requirements and what's in the federal requirements. 29753 requires really a couple things when you boil it down. One is that there shall be an assessment. It says HEP is one of the tools that can be used for that assessment, but there must be an assessment. And then secondly, there may be mitigation required. So that's optional. But when it comes down to what is the state, what are the parameters of the requirements, and when you hear protestants speak, they're going to be applying a very different federal standard that comes at a later date. The city of Wichita Falls knows that it must comply later with the federal process on 404 permitting. And in fact, it's no secret. Special condition 7A of the draft permit would require compliance with that federal law. It's at a different time. Commissioners, on the third issue, now reserve the time for my rebuttal. The ability to authorize a single amount of water for multiple uses, this is plainly allowed by section 11.023E of the Water Code. The legislature, just a few hundred yards from here, has made clear that that flexibility is needed, particularly when you have a reservoir system like we have in this case, like Arrowhead, Kickapoo, and Ringgold. And so that flexibility is permitted expressly by law. It's in the substantive regs that are there. And so as you listen to the arguments of protestants, I would ask you to listen for two things. One, listen for what is the TCEQ rule? What is the actual TCEQ rule at issue? And two, where is it that they are asking Commission ED staff to deviate from its practices of processing water rights for years? So commissioners, with that, I'll reserve the balance of my time for rebuttal.
Thank you, Mr.
Thank you.
Vassar. Colleagues, any questions for Mr. Vassar? Seeing none, thank you, sir.
Lauren Ice for the protestants.
And we have some exhibits to set up if I may.
Great. When you're ready, Ms. Ice.
Thank you. Good morning, Chair, Commissioners. My name is Lauren Ice. I'm here on behalf of the O'Malley protestants. With me today is my co-counsel, Marisa Perales, as well as our clients, Justin and Shelley O'Malley, and their 3 young children. Also present today are many of the other protestants and families, too numerous to list, unfortunately, but who have traveled several hours from their homes in Clay County to be here today. And they have graciously allowed us the 10 minutes today. I will take the first 5 minutes addressing the city's deficient environmental assessment, and my co-counsel will then speak to the lack of need for this project. But we speak for all protestants when we ask this commission to adopt the ALJ's proposed order and deny the application for the Ringgold Reservoir. The city is requesting the right to divert 65,000 acre-feet per year from the Little Wichita River in Clay County. And this application depends entirely upon the city constructing a dam and a spillway in its neighboring county and inundating 15,500 acres at normal pool elevation. But according to applicants' own designs, the proposed reservoir would actually impact nearly 24,000 acres. That is after taking into account the new 100-year floodplain, and the reservoir would cause other direct impacts due to rerouting several local roadways. I mention these impacts because even though Chapter 11 of the Texas Water Code requires the commission, as Mr. Vassar says, to assess the effects of the permit on fish and wildlife habitats, no exception, the city admits that it did not include in its assessment anything but the direct effects from the dam, spillway, and normal pool elevation. Specifically, reading the actual TCEQ rule 297.53 requires the assessment to include the project site as well as, quote, potentially impacted habitat upstream, adjoining, and downstream of the project site. Applicant's expert admits that this assessment was not conducted. The TCQ rules also require the assessment to examine both, quote, direct and indirect impacts, as well as, quote, long and short-term effects to the watershed or ecoregion. Again, applicant's expert on the subject admits this assessment was not conducted. Finally, TCQ rules provide that habitat mitigation shall be considered only after it has established that there is suitable mitigation habitat available for complete compensation of the lost habitat. And that is also a quote from the actual rule. And as just explained, the initial assessment was far too limited, which means that the mitigation habitat units that the applicant proposes were also far too limited, and the amount of habitat mitigation is grossly underestimated. But also, the city's expert plainly admitted that the conceptual mitigation plan included with its application did not actually determine that the identified land was, quote, suitable mitigation habitat as required by your own rule. In effect, the city argues that these rules don't apply to them, and that these rules and the commission's authority to require mitigation is completely supplanted by some future 404 permitting process. It is not the protestants or the ALJs that confuse the 404 permitting process, it is the city. The city would read nearly all meaning out of Rule 297.53, and this interpretation is wrong for at least 3 reasons. First, it is the city that chose to pursue the state water rights permit before the 404 permit, and more than 7 years later, the city still has not submitted its 404 permit application. And it is the city that submitted its application with mitigation proposed. Now it's saying mitigation is not required. The TCQ rules, second, the TCQ rules anticipate that additional mitigation may be required during a federal process, and they require offsetting, not that the federal 404 process completely supplants the authority of this commission. And third, both the city and the staff's experts agreed that the Army Corps' jurisdiction is not coextensive with the jurisdiction of this commission. It does not have jurisdiction over terrestrial habitat. That would go completely overlooked in a 404 permitting process were it not addressed by you. This is not a harmless oversight. There are thousands of acres of upland and riparian terrestrial habitat in addition to wetland habitat that will be destroyed if this permit is granted. The city would have you ignore them, but we've brought with us some examples in these photos today. On your top left is an iconic Texas tallgrass prairie habitat. This example shows that the prairies near the Little Wichita are traversed in places by sloughs and oxbows. On your bottom left is an upland hardwood forest dominated by valuable native species. This would be lost to inundation. On your top right is an example of high-value natural depressional wetlands. And on your bottom right is an example of high-value riparian woodlands and forests that lie adjacent to the Little Wichita River and its tributaries. One of O'Malley's experts, Steve Nelly, a range and wildland management expert with more than 47 years experience all over Texas, said, "I have rarely seen an area so rich and unique in habitat as what I've seen in the footprint area of the proposed Ringgold Reservoir." And I'll just briefly wrap up. In closing, the city's habitat assessment and the proposed mitigation plan are deficient in scope, detail, and so dependent on some future 404 permitting process that they do not demonstrate compliance with our state water code and with this commission's rules. And with nothing more than these speculative plans, they would ask permission to take land from private landowners and irreparably destroy this land forever. And Ms. Perales will explain next. They want to do this without even a need for the project. Thank you.
Thank you, Ms. Ice. Good morning, Ms. Perales.
Good morning. Good morning, Chair. Good morning, Commissioners. Good morning, Ms. Smith. My name is Marisa Perales, and I'm with Perales, Allman and Ice. I'm Ms. Ice's co-counsel, and I'm speaking on behalf of the protestants here. We heard the city's attorney mention that, that the statute and the applicable rules allow for a permit to be issued for one single amount that covers all of the beneficial uses. That statute and that rule that they rely on pertains to the permit and the commission's authority to issue a permit and what that permit language can include. What we're talking about is an applicant's responsibility. And there's a separate statute and a separate rule that addresses an applicant's responsibility. The statute is 11.124 and the rule is 295.5. And based on the clear language in both the statute and the rule, A permit applicant must specify the amount of water it proposes to use for each of the identified purposes of use in its application. And the reason for this is because we don't allow speculative water rights. It's contrary to the public trust doctrine, and it's just not in keeping with good governance. Neither the city nor the executive director dispute that that's what the plain language requires in the statute and the rule. And in fact, the city's witness, Ms. Keel, acknowledged that she didn't include the amounts for each of the proposed purposes of use because she didn't think she needed to. Now, the city has argued that it's relieved of its obligation that's specified in the statute and the rules because of the fact that the TCEQ can authorize one single amount for all of the uses. But this argument is flawed for at least 3 reasons. As I mentioned, it conflicts with the plain language of your statute and your rules, and the agency's rule is its official interpretation of its statute. And that rule is 295.5, and the language is consistent, as I said, with the statute. Second, this is a mandatory requirement, not a directory requirement. And this was adequately explained, I think, in the PFD. But essentially, the water code specifies what should happen if this requirement is not complied with. And that is that no permit may be issued. That's in 11-134. And third, the facts of this case don't present you with a close call here. The city this is not a case where we have a small delta between what's been shown in terms of a need versus what is being requested. Here, the city in its report supporting its application argued that it had a need in 2070 for about 9,100 acre feet of water. Its request is for 65,000 acre feet of water and for a substantial reservoir. Now, let's just assume for the sake of argument that we can gauge how the 9,100 acre feet is expected to be used. Let's just set that aside and say we can kind of tell from the evidence how they intend to use it. That still leaves about 55,000 acre feet unaccounted for. And the city provided no evidence and never explained in its application how it would use all of that water. And that's not in dispute. And both Ms. Keel and the executive director's witnesses acknowledged that they didn't look for need in the application. They just didn't think that that was required. You've heard some argument about operational flexibility and the use of this reservoir in a reservoir system. And indeed, in the closing arguments, in the written closing arguments that were submitted to the ALJ, not in evidence, but in the closing arguments, there was some references to the BRA system operation permit as support for this idea that some system operation and flexibility has been allowed by the commission in the past. But as Dr. Alexander has acknowledged, the BRA system operation permit was a completely different animal. And this is different from that. In that BRA matter, the application that was submitted was not for a new reservoir. In fact, what it was an actual system operation permit application that showed.
Time.
And I'll just wrap up by
Go ahead,
saying,
finish your thought.
thank you. I'll just wrap up by saying that this is a single reservoir for 65,000 acre feet. There is nothing in the record to show how it's going to be used in connection with the other reservoirs in the system. And that distinguishes it from BRA. Thank you.
Thank you, Ms. Perales. Colleagues, any questions for Ms. Ice or Ms. Perales? Seeing none. Thank you.
Next, we have the ED. Good morning, Commissioners, General Counsel, and Public Interest Counsel. My name is Ruth Takita. I'm an attorney with the Environmental Law Division, and I represent the Executive Director, or ED. With me at the table is Dr. Kathy Alexander from the Water Availability Division. The ED views this application as straightforward. The record for this case establishes that this is a request from a municipality to authorize water rights for a reservoir project listed as a recommended strategy in a water plan developed and approved by Region B, one of 16 water planning regions across the state established by the Texas legislature. Region B's water plan was incorporated into the state water plan, which was adopted by the Texas Water Development Board. The state water plan serves as a guide for state water policy. ED program staff reviewed this application, analyzed it under applicable requirements, concluded that it met requirements, and prepared a draft permit. The parties' positions on the TCEQ review process varies. The applicant agrees that it was appropriate. The ALJ and the protestants believe that the review was inadequate, particularly the environmental review and assessment of need for the proposed reservoir. The ED respectfully disagrees with the ALJ and the protestants on these issues and more, as discussed in the ED's exceptions and replies to the PFD. However, the ED addresses these two particular issues now. First, staff's environmental review was consistent with established program practices and procedures, including acceptance of a conceptual mitigation plan. The record reflects that program staff had a role in the stream assessment, pre-application studies, and work performed during various components of the habitat evaluation. The record also reflects that the federal Section 404 permitting process may impact mitigation requirements for proposed reservoirs. Second, need for the proposed reservoir was demonstrated by its inclusion as a strategy in the state and regional water plans, which are in the record and which ED staff have historically relied upon. Based on the evidence presented in the hearing, the ED position on this application has not changed. The ED recommends that the application be granted because the City of Wichita Falls has carried its burden of proof and has met all applicable requirements for issuance of the permit. We are available for questions, and thank you.
Thank you, Ms. Takeda. I have none. Colleagues, any questions? Seeing none? Go ahead and hear from the Office of Public Interest Counsel. Good morning, Mr. Martinez.
Thank you. Good morning, Chairman, Commissioners, General Counsel, and Executive Director. I am Eli Martinez with the Office of Public Interest Counsel for the record. We participated in this case and have reviewed the evidence, briefings, and proposal for decision, and we generally agree with the administrative law judge and support his alternative recommendation for a more appropriately sized reservoir based on the city's need for firm water supply, as reflected in the state and regional water plans. We do have several points we would like to address from the PFD, however. As for the requirement to specify the amount of each proposed use, we agree with the PFD that the permit must state the amount to be used for each purpose rather than simply listing a total maximum amount for all proposed purposes in any combination or singularly. This requirement is stated clearly and directly in Texas Water Code Section 11.124A and in our rules at Section 295.5, which mandate that in multiple purpose applications, the application shall expressly state an amount of the water to be used for the multiple purposes as well as for each purpose of use. We disagree with the PFD that denial of the permit is necessary on these grounds as the application and permit may yet be corrected. As to habitat assessment, we agree with the PFD and the protestants that the HEP study area incorrectly excluded 100-year flood areas that could be potentially impacted in a way that necessitates mitigation. Certainly construction of a road and the transformation of an upland into a floodplain do in fact constitute potential impacts. Further, we share the PFD's concerns that the baseline habitat units undervalue the existing habitat in light of the protestants' testimony that the city's sample sites used to value the combined grassland and oiled field habitat type were not representative of the area to be inundated. Most importantly, we strongly disagree with the contention that our 297.53 habitat mitigation requirements are moot and should be wholly deferred to another federal governmental entity under the 404 permitting process. Under our rules, the commission may require the applicant to take reasonable actions to mitigate adverse impacts on fish and wildlife habitat. And the goal of the mitigation of wetlands is to achieve no net loss of wetland functions and values. The rules further direct the agency to offset mitigation required pursuant to the federal review, indicating that the commission must act after the 404 process is completed, or at least concurrently, and offset the requirements set forth in that review, but maintain any additional action that may be necessary to mitigate net wetlands loss. Here, the evidence shows that the cities have studied misclassified about 250 acres of habitat cover type as open water or riverine, the majority of which should have been classified as a wetland cover type. These types of deficiencies are within our purview and regulatory framework and should be addressed rather than entirely deferred to another agency. We further agree that the city's conceptual mitigation plan is insufficient and does not establish that suitable mitigation habitat is available for complete compensation of lost habitat. Lastly, as to whether the appropriation is reasonable and necessary, the best evidence in this respect is the regional and state water plans themselves, which have already painstakingly identified water supply strategies for the applicable regions and the entire state based on projected needs over time. The city's water shortage, as projected in the 2021 Regional Water Plan, is 10,864 acre feet, and the ALJ's alternative recommendation for a 9,110 acre foot diversion right would generate a firm yield of 27,000 acre feet per year in the reservoir, which far exceeds that amount and is a figure that generously accepts the applicant's 20% reserve supply proposal and its population projections, and it would also potentially allow for system operation of the city's reservoirs to provide a more stable and reliable supply for citizens, industry, and the environment. Water is obviously one of life's most important resources, and in this day and age of recurring droughts of seemingly increasing proportion, need is axiomatic. Yet the resource must be shared reasonably, and in our estimation, the ALJ's alternative recommendation here best accomplishes this balance. As we stated earlier, any remand or further processing should also require revisions specifying the amounts that will be beneficially used for all of the expressed purposes of use, and effectuates a concurrent mitigation review and plans for complete compensation of lost habitat and net zero loss of wetlands in accordance with our own reviews. Thank you. I'm available for any questions.
Thank you, Mr. Martinez. Colleagues, any questions for Public Interest Council? Seeing none. Mr. Vassar, you have 5 minutes for rebuttal.
Thank you. Thank you, commissioners. As I said when I wrapped up my initial remarks, I asked you to listen for what the TCEQ requirements are. What you heard were a lot of references to eminent domain, to some standalone needs analysis that will take place during the federal process, as well as costs and inundation issues. These are interesting topics. They fall outside of the jurisdiction of the commission, respectfully. I will address several of the comments that have been provided, first on the habitat assessment issue. Experts matter. Michael Votaw, the city's expert on this issue, has used HEP and has conducted these habitat assessments for decades. He did a desktop analysis. We did, in fact, look at everything that was potentially impacted, including downstream, and it's in the record. By contrast, commissioners, the experts for the O'Malley's conducted a 2-day helicopter flyover. And in fact, as is shown in the record, one of the two experts was emailing U.S. Fish and Wildlife Service to ask about how HEP was performed. Experts matter, their qualifications matter. Michael Votaw did what was required under the applicable rules. Besides, mentioned some of the language in the rules. It's found in subpart F of 29753. As shown at the very outset of that, these are guidelines. The ED's briefing points out that these are guidelines that can be used if mitigation is in fact deemed to be required. Commissioners, with respect to the issue of need, I just want to make something clear. There has never been a TCEQ requirement. In fact, it's contrary to existing law and the Constitution of this state to match up molecules or acre feet with some particular contract need. It was not required in BRA SysOps. And in fact, in that particular case, it said you're looking out 50 years, 50 years. And so are we really going to require some precise connecting the dots between those two? What it comes down to is there's no sort of a Goldilocks perfect size reservoir. In fact, we're supposed to be maximizing the potential of the use. It was stated that it's not in the record that we intend to use the reservoirs as a system. That's not true, commissioners. In Russell Schreiber's testimony demonstrates exactly how Lake Ringgold will provide that very benefit when it may be able to capture flows downstream where you would not otherwise upstream. Finally, with respect to the issue of appropriating a single amount of water for multiple uses, again, the statute provides that you have this flexibility. The 295 requirements on procedural rules say this is what the commission staff, ED staff need to process an application. When you get to the substantive rules in 297, it discusses how you have the ability to use those for multiple purposes. And so, commissioners, with that, we do agree with the point that was made over. This is not a close call. When you look at the actual TCEQ rules and the statutes that govern, we have met our burden. The next route is coming. We don't know when. The city is preparing and is preparing this part of the step to make sure that it can meet a water supply, a water secure future. So commissioners, we respectfully ask that you approve this permit, grant our exceptions, and we appreciate your time today.
Thank you, Mr. Vassar. One thing I want to clarify with council before, thank you, sir, before I proceed with my remarks. All right, colleagues, this is obviously a matter with numerous complex issues, a very big record. I was just asking council to refresh my recollection on one of the facets, one of the many facets of this record and of the legal issues in front of us. On several of these issues, I think that ALJ's work is sound. However, in my view, there are a number of instances where the judge misapplied the law and policy. So bear with me as I lay out this analysis, and it's unavoidably long. Let me begin with what I think the judge got right. I agree that unappropriated water is available in the source of supply, and that the proposed appropriation would not impair existing water rights or vested riparian rights. I agree that the proposed appropriation is intended for beneficial uses. I agree that the appropriation is not detrimental to the public welfare. And I agree that the ALJ's handling of the assessment for in-stream uses, water quality, and groundwater, and the proposed special conditions that resulted from those reviews, that handling was appropriate. I also have no concerns with the proposed findings on the applicable dam safety requirements or the proposed findings on the administrative requirements for the diversion point or diversion method. I also support the special conditions establishing the construction period with possible extensions and the bed and banks authorizations. And I have no reason to disturb the 70-30 split on the transcript costs. Now I'll turn to the instances where I believe the ALJ failed to follow precedent or otherwise misapplied policy or law. First, I believe the ALJ misapplied the statute and rules concerning the specificity of information required in the application materials for issuing a multi-use permit. The ALJ has elevated application information provisions over the Commission's core decisions, whether the appropriation is intended for beneficial uses and whether the Commission can appropriate a single maximum amount of water for multiple use purposes. The Commission has a well-established legal interpretation that the agency's water rights applications information requirements are directory and not mandatory when the Commission considers a water right permit. The Commission has supported this position in multiple past water use permit matters and in their respective court appeals. I do not find that the ALJ has convincingly distinguished this precedent. The Commission has long found policy reasons to afford these types of projects flexibility to maximize the water amounts for multiple uses and to distribute allocations according to an area's needs. Accordingly, I would support amending the findings and conclusions on this issue to focus on the appropriateness of the draft permit's approval of a single maximum amount of water for 4 proposed beneficial uses under 30 Texas Administrative Code Section 297.43C and Texas Water Code Section 11.023E. Second, I believe the ALJ has misapplied the law and policy governing fish and wildlife habitat assessments and how to exercise the commission's discretionary authority to consider special conditions for the draft permit. When considering a new large appropriation, the statutes direct the commission to assess the effects of the permit on fish and wildlife habitats, and then grants the commission the option to require an applicant to take reasonable actions to mitigate adverse impacts. The statutes also allow the commission to consider a habitat balancing test when considering whether to impose mitigation actions, and requires that the commission offset any mitigation requirements imposed by the federal reviews if the commission does decide to impose mitigation conditions. What these statutes do not do is they do not direct the commission to deny a water use permit outright based on its habitat assessment. Based on the record, I believe that the city study area contained in the habitat evaluation procedure study was appropriate for the project site of Lake Ringgold. I believe that the ALJ inappropriately applied portions of 30 Texas Administrative Code, Section 297.53F, that addresses mitigation for unavoidable wetland loss with the separate fish and wildlife habitat review to support the proposal for decision's conclusion that a more expansive habitat review was required. I find that the details of the habitat evaluation procedures were sufficient under how the commission interprets its habitat assessment responsibilities. I believe the record supports that the city's conceptual mitigation plan includes reasonable measures to mitigate adverse impacts on the inundated habitat. I'm also comfortable with the commission's historical policy and practice of relying upon and incorporating a special condition for the federal wetlands requirements that is mandated by statute. I conclude that the draft permit special conditions for mitigation are appropriate and consistent with other permits for large reservoirs. Accordingly, I would reject or modify some of the ALJ's findings on the habitat evaluation procedures and mitigation plan based on improper statutory and regulatory interpretation, and conclude that the applicant met its burden to establish that the draft permit contains the necessary conditions to maintain in-stream uses and mitigate adverse impacts on fish and wildlife habitats. Finally, while I agree with the ALJ's determination that the applicant met its burden on avoiding waste and achieving water conservation, I disagree with the judge's analysis of whether the proposed appropriation addresses a water supply need consistent with state and regional water plans. I believe the ALJ's approach to the need review would set a new precedent that is inconsistent with the law and contrary to the state's regional planning process, as well as the policies behind that process. The ALJ appears to create a new heightened demonstration of no feasible alternative to a reasonable and necessary amount, and has selectively cited rule language that is applicable to the separate alternatives and conservation review. Although the ALJ applied an improperly strict standard concerning the city's need demonstration, I believe that the ALJ's factual determinations concerning the applicable state and regional water plans nonetheless provide the basis needed for the commission to determine that the draft permit is consistent with water supply needs identified in those plans based on a unified reading of the statute. Finally, I recommend that the commission reject the ALJ's factual findings on reservoir size, reserve capacity, and population projections that the ALJ included, because I do not find them to be necessary or determinative under my reading of whether the proposed allocation addresses a water supply need consistent with the plans under Texas Water Code, Section 11.134B3E. So that was a lot. Thank you for bearing with that. I hope you were able to hang with me, and I'm happy to review any of that. But that is my analysis in full, and I'd like to get your reaction to that, and just talking about how we might organize this discussion. We can work through any issues that you have with that. If at least two of us form some sort of consensus, I have a more detailed document that lays out the specific changes that I would proposed for the order, and we can, if we get there, share that, review it, and perhaps move towards a motion. So Commissioner Janeka, based on what I laid out, what are your reactions?
I agree with you that this is a matter involving many a number of issues, and I don't think that I have anything to add that substantively differs from the points you raised. I appreciate you highlighting your points of agreement and disagreement with the ALJ, and I think that they're consistent with my reading, interpretation of our agency procedures, the state laws and rules that we've in place. I'll stop there.
All right, thank you, Commissioner. Commissioner Gonzalez?
I appreciate your very detailed analysis. I also came to different conclusions on the 3 areas used by the administrative law judge to recommend denial of the water use permit to the city. First, I do not agree that the ALJ appropriately deemed the city's application due to the lack of specific volumes for each proposed beneficial use. The ALJ has essentially concluded that the lack of specific water volume information for each use in the city's application is a legal gotcha, preventing the agency from commencing its technical review and processing the permit. I support the Commission's past practice of applying the Chapter 295 application content rules as directory rather than mandatory. The Commission is clearly authorized by statute to issue a total amount of water to be diverted between beneficial uses, and I find policy considerations to afford these types of projects flexibility to maximize the water uses. Second, I believe the ALJ misapplied rule language to greatly expand what is ordinarily sufficient to review whether and how to mitigate any potential adverse effect of the water appropriation on habitats. The Fish and Wildlife Protection Statute, when applicable, requires a habitat assessment in some form and an option to add habitat mitigation conditions with the leeway to not impose them when considering other habitat benefits and offsetting any mitigation conditions required by federal permitting. HIP studies are accepted methodology for the Commission to sufficiently assess adverse habitat effects, and the ED's recommended special conditions are consistent with other state permitted reservoirs. Finally, I'm uncomfortable with the unprecedented breadth of the ALJ's proposed needs analysis. Not only do I find it based on an incorrect reading of the controlling statute and a misapplication of our rules, but importantly, I find that it shows a lack of understanding of how reservoir systems operate and provide reliable water supplies designed for future uses and inevitable sedimentation. I believe the record reflects that the proposed water supply and the city's intended uses meet a need consistent with what has been identified in every approved Region B water plan. And based on that record, I do intend to vote to approve the draft permit to the city.
Okay, thank you, Commissioner Gonzalez. I think the changes that I'm going to propose to the order address your concerns, but I'll let you be the judge of that and make sure that Commissioner Janeka is all right with those changes. So what I propose we do is I'll ask Ms. Smith to circulate copies of that document, and why don't we take about 10 minutes for recess to allow time to review that, and then we'll come back and see where we are. So the time is 10:19 a.m. Why don't we reconvene at 10:30? And we are in recess. So the time is 10:36 a.m. We're having various technical difficulties, including the door being jammed, still sorting through those. I'm going to propose we take a brief recess, but let's not go too far. We're in recess. Yeah. May I ask you a question? Is this a red light or a green light, or is it just an on light and an off light? 'Cause I can't see the difference between red and green. That's green? Green? Okay. We're back after a short break, and Ms. Smith has an announcement.
Just as a bit of housekeeping, we understand that the audio on that first item may have gone out about the time when the motion was made, seconded and approved. And just to let everyone know who might be watching the streaming version, we did get a recording of it in the room, and that recording will be available on our archived meeting in the coming days. Thanks.
Thank you, Ms. Smith. And if you'd like to go ahead and call item 2.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of HK Real Estate Development, LLC, for Texas Pollutant Discharge Elimination System Permit number WQ00161-50001. The order of presentation will be the applicant, followed by the protestants, the ED and OPIC. Each party will have 5 minutes of oral argument time. The applicant may save time for rebuttal as it bears the burden of proof on this application. I believe we will be beginning with the applicant, Helen Gilbert.
Good morning, Ms. Gilbert.
Oh, got to start over.
Let's do that and start the clock over and have it all on the microphone. I'm sorry I didn't catch that.
Good
Go
morning,
ahead. Good morning
Commissioners,
again.
General Counsel. I'm Helen Gilbert on behalf of applicant HK Real Estate Development, LLC. This is not like your normal PFDs in this matter, to the extent there was no hearing on the merits. There was no hearing on the merits because the ALJs properly dismissed all the issues on summary disposition. The protestant had ample opportunity, now representation by 3 different lawyers, and they simply did not address the 6 issues that you referred in your interim order. As a result, the only evidence in the record is the administrative record, Exhibit 1. So while it's unusual from that standpoint of no hearing on the merits, it's really a very straight up application of Senate Bill 709. Under that statute, no rebuttal evidence means the applicant's prima facie case is established conclusively and meets all applicable state and federal requirements, and there is no genuine issue of material fact, and summary disposition was proper in this case. The only issue that the protestants discussed was wholly different than the issues that you referred in your interim order. Nor did the protestant move to add issues or modify issues, which they could have done under limited circumstances under 2003-047F. We have to try the case on the issues that you refer, not issues outside of your jurisdiction. I think Council in item number 1 touched on that for a moment for the city. But we have to focus on the issues that you refer and develop that evidence. Even if we were not confined to the issues that you referred in your interim order, at the end of the day, this protestant is a downstream landowner concerned about flooding and trespass. The fact pattern here is really indistinguishable from the facts in the sort of famous Domel versus Georgetown case. It's squarely addressed by the old law, but good law in Hoffs v. Short by the Supreme Court. As a matter of law, applicants' permitted discharge is not a trespass, and water courses don't have to be continuous and may be dry for long periods of time, like many intermittent streams across the state of Texas. Commissioners, we thoroughly briefed the issue of water course. Water course, again, was not one of the issues
referred in your interim order. There was a live hearing on that. There were 2 briefing opportunities on that, and then exceptions, so really 3 different opportunities. Applicant requests that you adopt the proposed order with the 1 noted change to finding of fact number 19. We request that you issue the permit as drafted. And just to underscore, there's no basis to remand this case, not even the appearance of new counsel communicated to the parties this morning at 9:04. This has already been pending for over 2 years, and the protestants have received all the process that they are due. I'd like to reserve the balance of my time, and I'm happy to answer any questions you might have.
Colleagues, any questions? Thank you.
We have Natasha Martin for the protestant.
Morning, Ms. Martin.
Good morning. I'll step back a little bit here. Chairman, Commissioners, General Counsel, my name is Natasha Martin, and I represent Fraser LLC. With me today is co-counsel Bobby Salahi, and the Fraser family has joined us online. I want to note that the Fraser family is not opposed to the pending motion to withdraw before you today, motion to withdraw counsel. This isn't just a business, it's the Fraser family's legacy. It's 340 acres of land that could seriously be harmed by the discharge from this wastewater treatment plant. This case concerns 1 acre-foot every 2 days being dumped onto our client's property, which is not discharged into a water course. The permit overlooks that 80 acres of my client's property will become a dumping ground for HK's effluent. The applicant will argue that the area is a dry bed creek or that it's an intermittent stream, but the Fraser family's evidence clearly shows that it's not. You must reject the PFD because the ALJs fail to properly apply the summary disposition standard. Applicant is only entitled to summary disposition if there's no genuine issue of material fact with the record, like pleadings, affidavits, and discovery. In granting the summary disposition, the ALJs ignored record evidence put on by the Frasers. I'm starting with issue B, and then I'll go to A and C. Issue B, whether the discharge route is adequately characterized in accordance with Rule 309.12. This rule requires that the commission determine whether or not a discharge route is water in the state. The rule requires a proposed site to minimize possible contamination of water in the state. By citing 309.12 in your interim order, you referred to SOA an analysis of whether or not this route was in water of the state. The very title of the section is Selection to Protect Water in the State. That's the last time I'll say that. The Frasers were right to put on evidence that there's no connection between Sandpit Creek and the San Antonio River. This was evidence that supported issue B. Spoiler alert, the discharge route over my client's property is not water in the state. Texas defines state water as several water bodies, including rivers, streams, lakes, basically something with a bed and banks. Consistent with 309.12, Sandpit Creek, Mr. Fraser testified that there's no channel on his property and no connection between Sandpit Creek and the San Antonio River. In fact, he testified that the creek ends on his property and water largely stays on his property in a low point, in a depression. Based on his detailed study of the elevations and topography in his testimony, water would need to travel uphill to discharge into the San Antonio River. I'll also note that because determination of water in the state is important for this application, the applicant attempted to create a connection between Sandpit Creek and the San Antonio River by annotating a USGS map by showing a blue line connecting the two. However, in discovery, HK admitted that this line did not represent a continuous water course. The record indicates that the applicant manipulated this demonstration in order to show a connection. Mr. Frazier testified extensively to this mischaracterization, and that falls squarely under issue B and 309.12. All of this summary disposition evidence the ALJs failed to consider. Further, issue A is whether or not the draft permit adequately protects water quality, whether a proper description of the discharge route, without a proper description of the discharge route, nobody can know for certain whether this draft permit is going to adversely affect the water quality in this ponding area, in the depression that I described earlier. No review was done on the water quality impacts in that pond. And as Frazier testified, the water will inundate his property. Without doing that determination of the ponded water, the applicants have failed to show that the draft permit will meet all state and federal environmental laws, thus failing to meet their burden. My last point, whether the draft permit is protective of use and enjoyment, there is a little more than a page and a half of testimony that this property is used for croplands, used for cattle.
That's time.
That's time. Okay,
Why
might
don't
I?
you just
Okay,
finish your thought?
yes.
Thank you.
So under the standards, you're required to show that existing uses will be maintained. The existing uses to use it as a crop, as a farmland will be maintained. The ALJs ignored this evidence. All of these are genuine issues of material fact, and they need to be litigated. We ask you for that reason to return this to a hearing on the merits.
Thank you, Ms.
Thank you.
Martin. Colleagues, any questions for Ms. Martin? Seeing none, thank you. As you're walking back to your seat, I'll just share an observation, and that is that the allegation that evidence was manipulated is pretty strong. It's distracting. It's unnecessary to your arguments, and I don't particularly appreciate those types of arguments. They don't appeal to me. Just to give you a sense of how I'm reacting to that portion of your argument. Ms. Gilbert, we'll give you your rebuttal. Oh, excuse me. Right. Let's hear next from Executive Director staff.
Good morning, Chairman, Commissioners, General Counsel, Public Interest Counsel. For the record, I'm Bradford, the Environmental Law Division. With me today is Robert Sadler of the Water Quality Division. The Executive Director agrees with the Administrative Law Judges or ALJs findings of fact and conclusions of law as referenced in the proposal for decision or PFD on the 6 referred issues. The ALJs, the Honorable Katrina D'Angelo and Shelley Docket, found that the draft permit is adequately protective of water quality, that the discharge draft is properly characterized according to Title 30 of the Texas Administrative Code or TCEQ rules, section 309.12, that the draft permit is protective of the requested use and enjoyment of the property, that the facility
that the facility is adequately protected from inundation as required by TCEQ rules, chapter 309, that the draft permit adequately addresses nuisance odor according to the TCEQ rules, section 309.13, and finally, that the applicant complied with the requirement in the TCEQ rules, section 39.405G, to make a copy of the administratively complete application available for public viewing in the county in which the facility is located. The ALJs also found that the prima facie demonstration, which was established through the filing of the application, other sufficient supporting documentation in the administrative record, and the ED's draft permit and preliminary decision was not rebutted by the requester. Likewise, the Executive Director agrees with the requester's exceptions to the PFD. The Executive Director agrees with the ALJs and the applicant that the requester did not address any of the referred issues in requester's pre-filed testimony. The Executive Director respectfully suggests that the Commission deny the requester's exceptions and issue the draft permit as drafted. Thank you, and we are available for questions.
Thank you. I have none. Colleagues, any questions for Executive Director staff? Seeing none, let's hear next from OPIC.
Good morning, Chairman, Commissioners, and General Counsel, Executive Director. My name is Eli Martinez. I'm with the Office of Public Interest Counsel for the record. We participated in this case and advised the judge at the pre-hearing conference to not issue such summary judgment in this matter because we believe that evidence regarding the hydrological continuity of the discharge route and whether Sandpit Creek indeed connects to the San Antonio River as indicated in the permit is relevant to and has implications for several of the referred issues, including use and enjoyment of property, potential impacts on groundwater, and the adequate characterization of the discharge route. While it is true the commission phrased the discharge route issue with respect to section 30912, which falls under a subheading regarding siting, the rule does reference operational features, and the issue was referred in response to a hearing request that clearly described the hydrological connectivity concern, or at least did in its replies. Further, the phrasing adequate characterization of the discharge route implies that the intended analysis would go beyond the footprint of the facility itself. The issues related to use and enjoyment of property and groundwater contamination are not so constrained, and pooling of water on the protestant's property could result in either of those conditions. We make no argument as to the persuasiveness of the evidence, only that summary judgment was premature and genuine issues of material fact remained. This is still our position. Thank you.
Thank you,
For any
Mr.
questions.
Martinez. Colleagues, any questions for Public Interest Council? None? All right. Now, Ms. Gilbert, you have an opportunity for
Thank you, Chairman. As much as I dislike references to manipulation of data by good engineers with stellar records, I even more dislike references to evidence outside of the record. The only evidence in this record is the administrative record, which is Exhibit 1, the application draft permit and notices. There was no evidence put on in the form of pre-filed testimony. Protestant offered they didn't offer pre-filed testimony at all. They filed their pre-filed testimony. It wasn't offered into evidence. It wasn't admitted by the administrative law judge. So references to discovery, references to what the landowner might have said is not evidence that you can base your decision on here today. So references to depressions, inundation, all those things that you heard about earlier is really outside of the scope of what you can consider. But all I would add about 309.12 is if you wanted us to look at whether Sandpit Creek was a water course or not, you would have referred that issue. And what you did refer is whether it was described accurately in accordance with 309.12, which is a location standard. It deals with contamination of water, specifically groundwater. It looks at considerations of geological processes, soils, things of that nature, and the protestants simply didn't address that or any of the other issues. Thank you.
Thank you, Ms. Gilbert. Mr. Martinez, I now have a question for you. What record evidence raises a material fact issue?
I was referring to the testimony regarding there being no hydrological continuity between Sandpit Creek and the San Antonio River that was described in the draft permit.
All right. Thank you. Colleagues, any other questions or comments at this point? Yeah. I understood that to be record evidence that was sufficient to raise a material factual dispute. I think because Mr. Frazier has presented some evidence to rebut the presumption that summary disposition is not appropriate here. So I would remand this matter to SOA for a hearing on the merits to consider whether the applicant adequately characterized the discharge route, and because the discharge route may inform on the other two issues that survive, that is whether water quality is protected and use and enjoyment of property, I'm inclined to include those two issues as well. How did you see it?
I am in agreement. I found with OPIC's findings on this that this did raise to that level of issue that I thought would be appropriate to see fleshed out, and a remand is appropriate.
Thank you, Commissioner Janeka. Commissioner Gonzalez.
I'm in agreement with you, Chairman.
All right, I think we're ready for a motion.
I move that we remand the matter to SOA to conduct a hearing on the merits on the following issues. A, whether the draft permit is adequately protective of water quality, including the protection of surface water, groundwater, and animals in accordance with applicable regulations, including the Texas Surface Water Quality Standards. B, whether the discharge route is adequately characterized in accordance with 30 Texas Administrative Code 309.12. And C, whether the draft permit is protective of the requester's use and enjoyment of its property in accordance with the Texas Surface Water Quality Standards. The hearing on the merits on issues A, B, and C shall include, but not be limited to, determining whether Sandpit Creek flows into the San Antonio River or terminates on protestant's property, as the nature of the water course and where it terminates inform whether the discharge's effect on surface water quality was adequately evaluated. I finally move, and apologies for not suggesting this earlier, but that we set a maximum duration of the hearing at 150 days from the date of the remand to the date the supplemental proposal for decision is issued by SOA.
Second that.
Motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the application for the creation of Persimmon Municipal Utility District. The parties have been notified that the commissioners will not take oral argument, but may ask questions. Those who have signed in will be noted for the record. And I also understand that Representative Sweener has asked Ms. Lucy Ross to read a letter on her behalf. As for item 1, as a courtesy, the commission allows members of the legislature to address the commission on items or their staff to read a letter to the commission at its open meetings. And as a reminder to the commissioners, your decision must be based on the comments, hearing requests, and briefs filed by the party. So with that, call Lucy Ross to the lectern.
Good morning, Ms. Ross.
Good morning. Oh, sorry, let me step away. I will be reading a letter written by Representative Aaron Sweener. I am writing to provide feedback regarding case hearing docket number D06162023-032, which pertains to the petition filed by Bailey Land Investments for the creation of the Persimmon Municipal Utility District in Buda, Texas. I represent the concerned residents and community members who are concerned about the ongoing Persimmon development project and its potential on our beloved city. I'm asking the Texas Commission on Environmental Quality to favorably grant a contested case hearing and to include the city of Buda as an affected party because of the numerous concerns about the environmental and health impacts of the proposed MUD. The lack of a comprehensive agreement between Bailey Land Investments and either the city of Buda or the city of Austin has led to a wide gap in final plans for the MUD. The pressing environmental questions raised by this development as a result cannot be ignored. The lack of clarity regarding water and wastewater service, roadway infrastructure, and tree mitigation measures are causing significant unease within our community. These uncertainties may pose a direct threat to the environmental quality of our region. Given the current drought conditions in Buda, one of our primary concerns revolves around the critical issue of water and wastewater supply for the Persimmon Development Project. Neither City of Austin nor City of Buda have confirmed provision of water for the Persimmon Development Project. Has confirmed provision of water and wastewater supply and are unlikely in the absence of a development agreement with Bailey Land Investments. Without provision from one of the cities, Bailey Land Investments will be dramatically escalating the cost of water to its residents and the impact on the local aquifers and streams. Bailey Land Investments have not yet acquired permits for water or wastewater and may not be able to, given the environmental impact and TCEQ's guidance to regionalize services when possible. Further balkanization of water and wastewater in the I-35 corridor, the fastest growing area in the country, increases the risk of management failures, environmental degradation, and potential harm to Texans. In addition, the Garlic Creek Parkway roadway infrastructure must be completed in a timely manner to mitigate potential emissions that could negatively impact residents. Stop and go traffic areas, multiply cars, PM 2.5 and CO2 emissions. Lastly, verification of Bailey Land Investments tree survey will give peace of mind to residents that proper tree mitigation and conservation is taking place to preserve Buda's environment. For these reasons, I request that TCEQ grant a contested hearing case on this MUD application and include the City of Buda as an affected party. I appreciate your attention to this matter and look forward to engaging in the necessary proceedings to protect the interests and well-being of our community. Respectfully, Representative Aaron Zwiener. Thank you.
Thank you, Ms. Ross. And we appreciate Representative Zwiener's interest in this matter and her service to our state. Ms. Smith?
And this is a matter that has no oral argument. And so
Thank
those
you.
who've signed in will be noted for the record.
So colleagues, this proposed MUD does overlap the City of Buda's ETJ and their water service CCN. The city's also raised personal justiciable interests that are relevant and material to this MUD petition. So I would grant the city's hearing request. Of the more than 40 individual requesters for hearing requests, none owns property within the district, and all but a few, in my view, failed to demonstrate how they would be personally affected in a manner different from the general public. I believe that Shauna Lee Husky, Brett Koger, Jesus Mares, and Cody Schoten have demonstrated a personal interest in connection with drainage or well contamination, and I would grant their requests, denying all others. Commissioner Janeka.
I found the same.
Okay, looks like we're in agreement and ready for a motion.
I move that we grant the hearing request of the City of Buda, Shauna Lee Husky, Brett Koger, Jesus Maris, and Cody Schoten, and deny all remaining hearing requests and refer the petition to SOA for a contested case hearing.
I second the motion.
Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of the application by U.S. Ecology Texas Incorporated for a Class 3 modification of IHW permit number 50052. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
So colleagues, we have a single request on this item. Ms. Castillo's property is more than 20 miles from the subject facility. She has failed to articulate how she would be affected in a manner different from the general public, so I would deny her hearing request.
I find the same.
We're ready for a motion.
I move that we deny the hearing request of Elida Castillo, that we grant the application by U.S. Ecology Texas Incorporated for Class 3 modification of IHW permit number 50052, that we issue the draft permit as recommended by the executive director, and that we adopt the executive director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, please call the next items.
That takes us to the enforcement docket, which are items 5 through 18, and the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division, and with me today are Amy Sedemeyer, Melissa Cordell, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 18. The total assessed administrative penalties are $172,138, with $23,713 deferred, $61,113 applied towards supplemental environmental projects, and $87,312 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. I have none. Any questions, colleagues? Seeing none, Ms. Smith, has anybody signed in to speak?
On items 5, 6, 7, 8, and 9, we have individuals who are available to address the commission if they have questions, but they haven't asked to speak.
Thank you. Mr. Arthur, what's the view from your office?
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports adoption of these enforcement orders as presented by ED staff.
Colleagues, I'm in the same place.
I move that we adopt items 5 through 18 as recommended today by the Executive Director.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 19 is the consideration for publication of and hearing on amendments to repeal of and the addition of new sections to 30 Texas Administrative Code, chapters 281, 328, 330, and 335. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Jarita Sepulvedo with the Waste Permits Division. With me virtually is Diane Goss with the Environmental Law Division. The proposed rulemaking would implement House Bill 3060 relating to the conversion of plastics and other recyclable material through advanced recycling technologies and implement Senate Bill 1397 relating to the requirement for an electronic copy of a permit application from the 88th Texas Legislature 2023. The proposed rulemaking would also repeal 3 rules determined to be obsolete, make minor programmatic updates, and revise incorrect rule citations or references. A hybrid public hearing will be offered on this proposal online and in person in Austin on June 20th, 2024. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 281, Chapter 328, Chapter 330, and Chapter 335. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you. I have none. Colleagues, any questions? All right. Thank you, Ms. Sepulvedo. Ms. Smith, has anybody signed in to speak?
No one is signed in on this item.
And what's the view from the Public Interest Counsel's office?
Good morning, Chairman, Commissioners, and General Counsel. I'm Eli Martinez with the Office of Public Interest Counsel. We reviewed the rule proposal package and we support approval as it is a legislative mandated effort that has potential benefits for the regulated community in terms of correcting outdated rule references and avoiding confusion in our regulatory processes. And there is also a benefit to the public in making permit applications more accessible thanks to the electronic posting requirements that are included in this proposal. We know also that the public involvement plan and alternative language requirements have been properly proposed, and we'll be attending the hybrid public hearing that will take place during the comment period. As always, we will monitor this effort as it progresses and apprise the Commission of any public interest issues that may emerge. Thank you.
Thank you, Mr. Martinez. Colleagues, we have a legislative implementation rulemaking here with some cleanup attached to it. It does touch several chapters, but I'm certainly ready to put out for public comment at this point.
Likewise.
I move that we approve the publication of and hearing on the amendments to, repeal of, and new sections within 30 Texas Administrative Code, chapters 281, 328, 330, and 335, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 20 is the consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 230. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Counsel. On behalf of the Executive Director, I'm happy to attend this water division. With today's key item, the water division. The purpose of this group proposal is to amend that very present administrative code chapter 230 to implement the provisions of Senate Bill
Senate Bill 2440 amended the local government code that establishes requirements for groundwater availability certification in the municipal and county plant application and approval process for proposed subdivisions when groundwater beneath the land serves as the primary source of water supply. The amendments include making groundwater availability certification a mandatory component of the plat application and approval process, establishing specific circumstances under which a municipal or county authority may waive certification requirements, and requiring that existing commission rules are continued in effect for plat applications filed before January 1, 2024. In addition to updating the rule to address the changes to statute, staff proposes 2 additional changes. First, the applicability provisions be replaced with general provisions that identify the purpose of the rule. Applicability is addressed by the local government code, and the charge to TCEQ is limited to establishing the form and content of the certification. Second, that amended forms are removed and replaced with references to TCEQ forms. The rules specify certification contents and transmittal requirements, and removing the forms themselves from the rule will allow them to be updated as technology changes. A public hearing will be offered on this proposal in Austin on June 24, 2024. Staff respectively recommends approval to propose the publication of and hearing on the Title 30 Texas Administrative Code Chapter 230. Staff also respectfully requests permission to make non-substantive revisions to comply with the Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Mr. Berhe. I have none. Colleagues, any questions? All right, thank you, sir. Ms. Smith, has anybody signed in to speak?
Yes, Jill Garcia with the Upper Trinity Groundwater Conservation District is signed in.
Great. Ms. Garcia, are you with us in the room or virtually?
Yes, I am here virtually. Can y'all hear me okay?
Well, yes, you're coming in loud and clear. Go ahead when you're ready.
Excellent. All right. Well, good morning, TCQ Chairman, Commissioners, and staff. My name is Jill Garcia. I'm a geologist and Assistant General Manager with the Upper Trinity Groundwater Conservation District in Springtown, Texas. I've had the opportunity to work with the district for close to 5 years now and have learned more about groundwater and environmental management than ever thought possible. To provide some scope, our district serves the counties of Parker, Montague, Hood, and Wise, west of the Dallas-Fort Worth Metroplex in north central Texas. Both Parker and Wise counties have been top counties in the state for water wells drilled in recent years. As these counties have experienced unprecedented growth, our office wanted to bring to light an issue that has emerged regarding the implementation of SB 2440. District staff work closely with landowners, water well drillers, and platting authorities, and through this process noted that many small tracts of land requesting replats and lots looking to subdivide into a few tracts, usually between 5 and 10 lots. Since there is no current definition of the phrase credible evidence as referenced in 2440, few to no options exist for landowners looking to sell and plat smaller subdivisions of land. If explicit determination of the phrase were established by the TCEQ, then we and other groundwater districts can assist and guide landowners on a standard that may not function as a full study as referenced in Title 30, Part 1, Chapter 230 of the Texas Administrative Code, but something comparable to assist in determination of groundwater quality and availability. With thoughtful development and sustainable growth at the forefront of everyone's minds this morning, our office appreciates the Commission's time and consideration on this matter. Thank y'all for y'all's opportunity, and our office is available for any questions.
Thank you, Ms. Garcia. So if I understand correctly, you're asking, golly, these mics are driving me nuts today. Is this working? Let's try that. Okay. I think my battery has run out, perhaps. All right. All right. Try this again. Ooh, this one works. Ms. Garcia, are you still there?
Yes, sir, I am.
Okay. Thank you for joining us today. Really appreciate your comments and your work with the Upper Trinity Groundwater Conservation District. I want to make sure I understand you correctly, and that is that what you're asking us to do is to include in this rulemaking a definition of credible evidence. Is that accurate?
Yes, sir. Yes, sir.
Okay. Let me begin with Executive Director's staff and just get your response to that. And I guess my question would be, is this an issue that you're aware of? And also, is this an issue that if we went ahead with the proposal as drafted would be properly noticed if we wanted to craft a definition for credible evidence?
Thank you, Commissioner. The credible evidence in the bill is not clarified. It says credible evidence. So our rules just pretty much in line with the statute. So we just refer the applicability of the rules directly in tie with the statute.
I understand. Okay. So we're parroting the statutory language, and we're really at the front end of this process, colleagues. And what I want to make sure is that we have an opportunity to consider this issue as we move forward with the rulemaking. And so I want to make sure that when we put this notice out, that this issue is properly noticed. And I think I might seek the advice of counsel. Fortunately, we have several lawyers in the room. Some of them are actually mine. And we can ask them whether the proposed rule as it's currently drafted, plus the discussion from the dais is enough to properly raise this issue such that if we were to create a definition for credible evidence, that it would not create a notice issue later, if that makes sense. So do you want to provide some legal advice, Ms. Smith?
Can we recess for a moment? And
Yeah.
I'll provide that.
Time's 10:20, excuse me, the time is 11:21 and we are in recess. All right, colleagues, what I'm going to propose is, belt and suspenders. It may be adequately noticed already, but I'll read a motion that would include that when we get to that point. And Ms. Smith, let me check to see if there's anybody else who is signed in to speak.
No one else is signed in.
Okay, let's hear from the Office of Public Interest Counsel.
Good morning again. Eli Martinez with the Office of Public Interest Counsel. We reviewed this rule proposal package and we support approval, as it is also a legislatively mandated effort needed to ensure consistency with the local government code, and the effort has potential benefits for home buying members of the public who rely solely on groundwater, who may be assured that groundwater supplies will actually be available to them. We note also that the public involvement plan and alternative language requirements have been properly proposed, and as always, we'll monitor as it goes forward and apprise the Commission of any public interest issues that may emerge.
Thank you, Mr. Martinez. Colleagues, I'll go ahead and make a motion and we can discuss it on the other side if there are any questions or concerns. So I am going to move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 230, as recommended by the Executive Director, and to include soliciting comment on whether to include a definition of credible evidence and what that definition would be. And that is my motion. Any discussion or comment or a second?
I'll second it.
All right, the motion has been made and seconded. All those in favor say aye. Aye. The motion carries. Ms. Smith, when you're ready, I'll ask you to please call the next item.
That takes us to items 21 through 22, which are the quadrennial rule reviews for 30 Texas Administrative Code, Chapters 5 and 299. And the Executive Director's staff is here to present these matters.
Good morning, Ms. Rico.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you are items 21 and 22, the adopted rule reviews of 30 Texas Administrative Code Chapter 5, Advisory Committees and Groups, and Chapter 299, Dams and Reservoirs. As required by Texas Government Code Section 2001.039, Executive Director staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notice for the review of Chapter 299 was published in the October 6, 2023 issue of the Texas Register, and the proposed notice for the review of Chapter 5 was published in the November 24, 2023 issue of the Texas Register, with a correction to the notice published on December 15, 2023. Each review had 30-day comment periods, and no comments were received for these rule reviews. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules in Chapters 5 and 299 continue to exist, and changes to the rules identified as part of this review process will be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of Chapters 5 and 299. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and staff attorneys assigned to these chapters are with us to answer any questions.
Thank you, Ms. Rico. I have none. Colleagues, any questions? Has anyone signed in to speak?
No one has signed in.
Mr. Arthur.
OPIC agrees that the reasons for initially adopting the Chapter 5 and 299 rules continue to exist, and we support readoption of the rules in each of these chapters.
Colleagues, I do as well. I'm ready for a motion.
I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code Chapters 5 and 299 without amendment as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item 23 is our public comment session, and we don't have anyone signed in to speak at this time. Pause and see if there's anyone in the room, and ask the chief clerk to unmute the line to see if anybody wants to talk.
I think it's fair to say that no one in the room is approaching the microphone. And is there anybody online who'd like to address the commission? All right, I think we can call the next items, Ms. Smith.
Items 24 through 27 are for closed session, and the commission will not meet in closed session today.
Thank you. And before we adjourn, I have a note of appreciation and thanks. And I can't read my own writing, so I'm going to put my glasses on to help me out with this. For those of you who don't know, Megan Tack, who leads the commission's agenda and SOA hearing section for the chief clerk's office, is leaving TCEQ for work in the private sector. And when I first heard about this, my voice inside my head said, oh no, oh no. It's going to be all right. Before I talk about what this means for the agency, I'm happy for the opportunities that Megan has, and wish her all the best in that. I want to talk a little bit about what she's meant to this agency. Megan has not only been outstanding at what she does, she's also had moments, multiple moments of really true heroism in my mind. For example, when the COVID pandemic descended on us, our commission agendas did not miss a beat. And we owe that to Megan. That would not have happened without her. In mere days, she stood up an entirely new method of business for us so that we could work virtually and continue our commission agenda work on schedule. Megan is reliable, knowledgeable, personable. She routinely meets challenges with a greater and determined force. Someone in the private sector is very fortunate. They've made an excellent hire. It is certainly our loss, but for Megan, we really appreciate her service to her colleagues at TCEQ and people of the state of Texas, and hope that she remains in our orbit, even if she is not within our agency. So Megan, thank you. We appreciate you. I think we're ready to adjourn at last. My microphone is working. It's 11:30 and we are adjourned.